As Kimberly noted previously, one of the hot-button issues in these new regulations is the due process concerns that some people believe that they raise. And an important element of due process is the ability to cross-examine an adverse party and a witness. Under the notice of proposed rulemaking, schools are no longer required to conduct live hearings where cross-examination would generally occur. This is problematic from a due process standpoint and is arguably contrary to the constitutional protections that public universities are required to offer. In fact, the Department of Education has explicitly noted that public institutions in Kentucky, Michigan, Ohio, and Tennessee are bound by the Sixth Circuit Court of Appeals ruling in Doe v. Baum. In that case, the court noted, quote, "If a university is faced with competing narratives about potential misconduct, the administration must facilitate some form of cross-examination in order to satisfy due process," close quote. Without a live hearing, it's unclear how public schools in the Sixth Circuit will meet their constitutional burden of providing parties to a contested Title IX matter with adequate due process. And while schools are not required to provide a live hearing, if they do conduct one under the new rules, the new regulations remove the explicit requirement that cross-examination be conducted directly, orally, and in real time. Coupled with the new requirement that the decision maker must screen all questions for relevance and permissibility before they're asked, it appears that the Department of Education is trying to create a scenario where all cross-examination questions must be prepared by the student and submitted to the decision maker in advance of any live hearing. This would greatly limit the effectiveness of cross-examination and potentially taint the decision maker's view of the case before the parties have had an opportunity to be heard. Additionally, taking regular breaks to allow the parties to submit new questions would also hamper the usefulness of cross-examination and needlessly subject all parties to a more protracted hearing process than necessary. Now, continuing with the analysis of cross-examination, under the 2020 regulations, schools were not permitted to rely on any statements made by a party or witness if they refused to submit to cross-examination. This provision has been struck down as unlawful and is currently not being enforced. In finding the provision arbitrary and capricious under the APA, which is the Administrative Procedure Act, the District of Massachusetts in Victims' Rights Law Center versus Cardona imagined a scenario where an attorney would advise their client not to attend a hearing so that inculpatory statements that they made, either within or without the process, could not be considered. And that case is currently on appeal to the First Circuit, but the appeal has been held in abeyance due to the issuance of the Notice of Proposed Rulemaking. Under the new proposed regulations, a party's own supportive statements cannot be considered if they refuse to submit to questions regarding their credibility. This is likely to pressure parties to submit to such questions either directly from the decision maker or on cross-examination so that their own supporting statements can be utilized in determining the outcome of the proceeding. However, this new standard does not apply to witnesses. And this is troubling, as allowing the decision maker to rely on witness statements that have not been probed for credibility, even if these statements cannot serve as the determinative factor in inferring responsibility, undermines the rights of the parties to confront witnesses and can lead to unreliable information impacting the outcome of Title IX matters.